my very great pleasure to welcome you this evening for this public forum on the judiciary checks and balances. I attended a public forum like this one in Memphis at the National Civil Rights Museum just a week ago. I was struck then, as I continue to be, by the significance of the role that the federal courts have played in the history of our democracy. As we approach our 250th birthday, I can think of no better time to remind ourselves of what our constitutional structure means in and to this country. If you've never heard of Keep Our Republic, you're not alone. I hadn't until a little more than a year ago, when I was asked to participate in one of its projects, the Article 3 Judges Coalition. KOR is a nonpartisan civil education nonprofit entity committed to the vitality of America's democracy by promoting trust in elections, the rule of law, and constitutional checks and balances. Article 3 Coalition, as it is called, A3C, is comprised of retired federal judges appointed by presidents of both political parties who are speaking out, among other things, about the principles of separation of powers among three independent and co-equal branches of government enshrined in our Constitution. As judges, we do not, as a rule, speak out. Sitting judges are limited by ethical canons that prohibit them from speaking publicly in ways that might call their impartiality into question. So what we do is frequently misunderstood. I am particularly irritated to the point of being driven to close to homicidal rage by individuals who ask, why don't federal judges follow the will of the people? It is my hope that if you take nothing else away from this evening's discussion, you will be able to respond with both certitude and conviction we are not supposed to. The name Keep Our Republic derives from a response made by Benjamin Franklin to a bystander one hot summer evening during the Constitutional Convention in 1787. The bystander said, "What kind of government is this cabal creating?" He famously and probably authentically replied, "A republic, if you can keep it." It is my hope that your presence and participation tonight demonstrate your commitment to doing just that. Thank you. Good evening. How are you, sir?
I am good. How are you?
I am fine, and we're delighted to welcome you. Senator Tillis is a friend of the judiciary. We have talked to him about issues of concern such as judicial security and the confirmation process, and he has always been responsive and engaged. And I'd like to take the opportunity to thank you for that and for being with us this evening. Would you like to just share your thoughts with us, or would you like us to bombard you with questions?
I kind of like being bombarded with questions. So to the extent that you all have any interest, but I think the subject of checks and balances are so important. In fact, I've traveled internationally recently, and I think the one thing that even among some of the most sophisticated politicos in Europe that's really lost on folks that are viewing the American experience is that there really are checks and balances at work most of the time, maybe not all of the time. And not only is the judiciary so critical to maintaining its independence, but we have a role to play here in Congress. And more recently, the dispute that we've had over presidential power is reaching a fever pitch, because we have people that when they're in the minority are always talking about a check on power, but when they get in a majority and DC is swept, either all Democrat or all Republican, you see the party in power make the mistake of conveying power from the legislative branch to the executive branch. And it's been a bipartisan failure, in my opinion, for about the last 75 years. So that's why the judiciary, the independence of the judiciary, and the judiciary check on the legislative and executive branches has never been more important than it is these days. And I'm trying to do my part to remind my colleagues that you can't have situational principles. You either believe in the separation of powers and checks and balances and advocate fiercely for your branch, or you don't if you're in the legislative and executive branch. And then I just want good judges who review the Constitution, the relevant laws, and call balls and strikes along the way.
I am delighted to hear that, and I'm sure the audience is as well. What are your thoughts? Members of Congress have introduced resolutions and held hearings on impeaching judges on the basis of their rulings. Do you have anything you'd like to share with us in that regard?
Is this the over 18 audience?
I think we can handle it.
That's bullshit. Look, that to me is absurd. Impeachment, and actually one of the reasons why I voted against, there were a variety of reasons, but one of the reasons I had a problem with any of the impeachment proceedings of late, let's say the impeachment proceedings of President Trump, is that we're treating this like a vote of no confidence. The impeachment process has presidential impeachments in particular. There's a long list and a long established history of how you go about doing that. And now you have people throwing around impeachment as a way to fire judges because you disagree with their rulings. Well, look, there are ethical and other mechanisms you can use if a judge behaves improperly or not in compliance with ethical standards. But for us to suddenly start getting rid of people and impeaching them because we don't like an outcome, I think is a banana republic way of dealing with the judiciary, and I think it's nonsense. And I felt like no stronger words than the words I used earlier in answer to your question to describe it. I think it's lazy. If you don't like the outcome of a ruling, appeal it. And then when it goes to the high court, then you have to live with it. That's how you deal with it. You don't fire one judge until you find one judge that agrees with you. I mean, that's probably more than anything else one of the greatest threats to judicial independence that we have in front of us in modern times. And I've seen Democrats too. If you remember, Chuck Schumer famously went to the Supreme Court steps that are right behind me and said he was going to unleash a whirlwind. And you say that about judges on the Supreme Court? My goodness. So the only reason I make that point is that's an example of bipartisan stupidity with respect to how we should be treating the judicial branch.
Thank you. Duly noted. After you talked about traveling internationally and some of the things you've seen and experienced. After the Supreme Court's ruling on the tariff issue, the president suggested that members of the Supreme Court were swayed by foreign interests. Have you noticed anything of that kind? Have you seen any evidence of that?
No, I think they were kind of swayed by the Constitution and prevailing laws personally. So I'll agree to disagree. It wasn't foreign interest. My gosh, there could not have been a clearer line of demarcation, right? We imposed tariffs. The president imposed tariffs and under the auspices of IEEPA or an emergency, saying that we had a trade emergency. Well, what kind of an emergency is I believe that the behavior of the administration and probably bad advice that the president was acting on undermine their argument from the beginning. You can't call it a trade emergency and then impose a 50% tariff on a country that has a trade surplus with us because you disagreed with a judicial outcome, Brazil. You can't impose a tariff on a country that has a consistent trade surplus with us. because it undermines the argument that you applied these under some sort of an emergency. I'm not an attorney. I mean, I watch a lot of forensic files and other law shows, but even this guy could figure out that it was being undermined within 30 days of the following the so-called Liberation Day, and rightly so. I've assumed that they were going to be overturned, and I'm glad that they were. It's not that I don't want the president to use devices like Section 301 and 232 to go after unfair trade practices, but he needs to stay within the lanes that we've defined as appropriate for the executive branch without congressional action.
Would anyone from the audience like to ask a question? I'll keep going if you, yes.
Oh, thank you. Sorry. A lot of my research and other research lately has shown that the public gets a lot of their information from Senate confirmation hearings, particularly of Supreme Court justices. And this is what informs their opinions of the judiciary. They don't know what the Supreme Court is doing, deciding cases day to day. And so my question is a lot of the behavior of senators during these hearings, the politicization of the court that happens based on the questions that are asked, informs how the public views the judiciary. And so I think that it's fair to say on both sides of the aisle, the tenor of these hearings have changed. We have systematic evidence to demonstrate that. How can we help fix this, right? Like, you fairly called.
It was the question, how can we fix this?
I mean, how can we
get to a question?
I get it. Look, Judiciary Committee is a goat rodeo on a good day. Back in December of 2014, after I'd won the election, Mitch McConnell called me up about 2 weeks later and asked me if I would serve on the Judiciary Committee. I said, Mitch, I served for like 2 years in the legislature on a Judiciary Committee. I'm not an attorney. I don't know why I make sense for being on there. And he said, that's actually why I want you on there, to maybe lend a perspective as a business person, and and maybe not always looking for that Perry Mason moment. But in answer to the person who asked the question, you need a Wayback Machine. And you'd have to go back to a time before Judiciary Committee hearings were televised and social media to change behavior. You need only, if you really want to be disgusted, look at some of these hearings and see the members at either end of the political spectrum using that moment in C-SPAN to send out a send me $25, $50, or $100, I am fighting for you. And what we also should do is probably take note of the people who are the most bombastic and how little they actually get done as a matter of legislative outcomes. So maybe we can't really change the behavior, but maybe we can point to the lack of productivity outside of fundraising and bluster to really make more members be held accountable for what they're saying versus what they're doing. But I think gone are the days of the of having a calm meeting. And by the way, the only reason I stayed on Judiciary Committee is we were able to convince the chair to create the subcommittee on intellectual property, which I've either been ranking member or chair of for going on 8 years. That committee gets work done, and it gives me enough to tolerate the big committee, which is generally speaking just nonstop attacks made for TV, made for fundraising sorts of events.
Thank you. And thank you for the question. I think what we were getting to was what he has observed. When you see that kind of circus atmosphere almost on television, it does give you a very jaundiced view of the process. It's always been politicized to some extent, but I think even more so.
But I will say, I think the role that every one of you can play and the population has to play is you don't criticize the person at the other end of your ideological spectrum when they do it. Give a voice to somebody that's at your point on your ideological spectrum that's behaving that way, and say, do you really have to do that? If we don't start having pressure from people that are generally supporters of these people who are behaving this way, it's not going to change. It's just going to continue to amplify. And it's one thing I'm not gonna miss. Every once in a while, like last week, I'll admit I lost my temper but it wasn't after a nominee. It was after somebody who's proven to be incompetent. And I guess the president believes that too, because he fired her 2 days later. So I'm saying sometimes maybe anger, if again it produces an outcome, then maybe anger is okay, but not just for made for TV.
I do have one question I think that would interest all of my colleagues. The Senate introduced legislation that would have tremendously enhanced the security that provides security for federal judges. Is there any hope that the House will take it up?
I think it will. It'll probably end up in a year-end appropriation bill, so it may not be the first half of this year. But I believe when we get to a year-end appropriation, look, we're seeing the threats to judges. I mean, we just had this weekend. I had two evacuations of 2 offices and 2 family members who had to have police come to their door in other states to clear a bomb threat. I just had somebody who's about to accept a plea deal this week for calling my wife directly and threatening her life. This stuff is happening not only to members of Congress, it's happening to judges. That's what happens when you can dox people, you can socially engineer them and try to get inside their head. We've got to do everything to protect them. And I'm absolutely an advocate for providing the additional resources. Congress just got additional resources in the last appropriation. I think we owe it to the Article 3 branch.
Thank you very much. Thank you for being with us. I really appreciate the extent to which Senator Tillis has always been responsive to our issues and concerns. So thank you for joining us this afternoon. We appreciate it.
Well, thank you all. Enjoy your evening.
Good evening, everyone. I'm Orange Quarles, for those of you who don't know me, and it is my honor and pleasure to be part of this program. Several months ago, Judge Duncan mentioned to me about Keep Our Republic. It was going on around the country, and she said, "Hey, you think we could do it here in Raleigh?" And I said, "Of course we can." And what do we need? Well, we need a sponsor. So I want to recognize our sponsor tonight, the A.J. Fletcher Foundation. So please give them a hand. And I want to thank all of you for being here this evening. I get the honor of introducing our moderator, Judy Woodruff. Judy and I go way back. We've been together on the Freedom Forum board for over 20 years. And her accomplishments are much too long for me to try and share with you tonight. But I urge you to go Google Judy Woodruff and look at everything she's achieved. Now, I won't hold this against her. She is a Duke grad. But before going to Duke, she actually went 2 years at Meredith. So needless to say, Judy knows a lot about the Triangle. She comes here all the time. She serves on the board of the Duke Endowment. She and I have been on the Freedom Forum board for over 20 years. Her list of accomplishments are long. She's been recognized the Al Newhart Media Excellence Award winner, the Gwen Ifill Media Excellence Award winner, and on and on and on. We know her from PBS, where she was anchor for a number of years. She also served as the host of Inside Politics for CNN. And the last couple of years, Judy has been going around the country talking to Americans, finding out why do we have our differences, but more importantly, how can we chill it a little bit and see more eye to eye than the things we don't agree with. And so we are delighted, Judy, that you were able to take the time to be with us. And as you can see, we've got a great turnout. So please, everyone, welcome Judy Woodruff.
Thank you. Thank you so much, Orange Quarles. And I could return the favor. Orange is such a, not only a great friend, but someone who is such an important member of this community in Raleigh and the state of North Carolina. Let's give Orange a big hand. Thank you. Thank you for that warm welcome, Orange. I'm truly delighted to be here. I was honored to be asked to sit with this panel of most distinguished jurists. We're going to have a conversation over the next hour or so, and I believe we're going to have time for some questions from all of you. So, and I think there are ways to submit those. So, I'll let you think about that. But I'm gonna just say a few words about each one of the judges who are sitting here, just so that you know a little about their background. You've been listening to Allyson Duncan, the former circuit judge for the Fourth Circuit. She served in that role from 2003 until 2019. Allyson, is that right? She was an appointee of President George W. Bush. So she has served the country with great distinction, and you just heard just a little bit of Allyson's talent in that conversation she had with Senator Tillis. Let's give her another hand. Thank you. And sitting next to Allyson is Judge Ursula Ungaro, who was from 1992 until 2021 the U.S. District Court judge for the Southern District of Florida, based in Miami. She was an appointee of President George H.W. Bush. Judge Ungaro, we are delighted to have you here. Thank you very much. Thank you. And seated on the other side for me is Judge Liam O'Grady, who was the U.S. District Judge for the Eastern District of Virginia, based in Alexandria. He was appointed by President George W. Bush, served from 2007 until 2023, the last 3 years as the senior judge of that court. Judge O'Grady. And finally, Judge Diane Wood. She was the U.S. Court of Appeals judge for the Seventh Circuit, based in Chicago. She was an appointee of President Bill Clinton. She served from 1995 till 2024. And for the last, I think, 7 years, you were the chief judge, and the last year, the senior judge of that appellate court. Judge Diane Wood, thank you very much for being here. So there's so much to talk about with what's going on in the country and in the judiciary right now, but I want to come back to you, Allyson, to ask you just a sort of a foundational question. Why was it necessary at that moment in time last year to create the Article 3 coalition? You said they turned to you to join it. What was it about that moment that required the creation of this organization? Oh, we have lots of them here. We have another. Here we go. You each need a mic. Here we go.
One of the things that I began to notice, and there are a lot of factors behind it, which you alluded to, the young woman in the fourth row back alluded to, when you see people in the Senate reacting to Senate judicial nominees. The incivility was peaking, and it was rising. I do not understand calling, well, I'm from the South. You don't call someone rogue or unprincipled or evil because you don't agree with them.
And that was some of the milder language.
There was language of that kind, and it troubled me deeply. Because when I was seated on the Fourth Circuit, we're not allowed to speak out. It is something that is very unusual. My colleagues in Europe say, but that violates your First Amendment rights. Well, yes, but we have life tenure. Most of them do not. They're term appointed. And we are held to the standard of not refraining from saying anything that shows bias or prejudice or prejudgment. And so since my colleagues could not speak, the impetus behind KOR and the Article 3 Judges Coalition is the retired judges can speak. We can be their voice. And that's what we've been trying to do.
So, and just picking up on that thought, you pointed out, Keep Our Republic, the Article 3 Coalition is nonpartisan, nonprofit, down the center, and yet you came into being at a very polarized moment, partisan polarized moment in this country. and frankly, several months into this very activist current administration. How do you square the two things?
I think that the context makes our reaction very understandable. We are not trying to engage in rhetoric, we're trying to inform, because a lot of what I hear reflects a lack of understanding about how the courts operate. It's very hard to explain to someone there is a difference between a judicial writ and an administrative writ. The Constitution prohibits law enforcement from searching and seizing someone's possessions or going in their house unless it's passed on, unless there's probable cause under the terms of the Constitution. An administrative writ has no such constraints, but most people don't know there's a difference. And so it's the why don't you follow the will of the people question that irritates me so badly. It was what I was seeing that evidenced the fact that people do not understand their judicial structure. And if you don't understand it, then you're really not in a position to pass judgment on it.
So let me turn to you, Judge Wood. I mean, this debate is happening 250 years after the founders started to craft what this country would look like. Declaration of Independence, a few years later, the Constitution came along. They spelled out Article 3, it's one of the shorter articles in the Constitution, but then along came the Federalist Papers. There was more detail there, if you will. Why are we still having this debate, this discussion about the independence of the judiciary all these years later?
Is this on? Yeah, okay. It's a great question, and I think it really stems from the fact that the Constitution itself is a pretty cryptic document. There is no separation of powers article in the Constitution, as there is actually in many of the state constitutions. There's no article that really spells out exactly how the checks and balances work, where we both have separate powers but interlocking powers. Presidents don't just name ambassadors or judges. They have to get the advice and consent of the Senate. Judges can't decide anything until the executive branch decides to bring a case before them. They're complex interrelationships, and that's what we've been working on really for the last 250 years.
Judge O'Grady, what would you add to that? Why are we still having this debate? I mean, yes, you're right. There was lack of clarity in what the founders did. As we said, a little bit more in the Federalist Papers, thanks to Madison. But why are we still debating, discussing, and especially right now? Why is this happening?
Well, I was listening to some folks a little earlier, and they were talking about this. There wasn't this great debate about the authority of the judiciary and the position that the judiciary had within the three branches of government until very recently. Well, picking up on what has already been said, the rhetoric is at a level which is unprecedented. The attack on judges is unprecedented. The rule of law is under attack. The judges are being criticized, and the public is losing faith. And it's because of the issue has been so prominent. And in answer to your question, I guess, every administration, when it comes in, it has an agenda, and it believes that the public voted them in, and that their agenda is important to a majority of the people who voted. And what's happened here most recently is that you've got an executive who believes in what they call the unitary executive privilege, and it's that he gets to handle all the the executive agencies, and he doesn't want any interference. And Congress didn't give absolute authority to the executive in a lot of the laws that they passed. And most of our emergency orders that we've seen come out over the last 14 months have been about whether Congress can, in writing the statute and the law that it gives to the executive, can limit it. You can't fire the commissioners in the Federal Reserve. You've got the Lisa Cook case that's coming up pretty soon, I think, hopefully for resolution. And so the battle is over, in large part, the executive power. And this executive group has grasped and it believes, and it's, you know, it's a repeat from 4 years before. And so they got their agenda together, and they very forcefully are driving their position. And the judiciary has been forced into a position where it now has to respond to all of these actions and follow the law as it's been written, not follow the wishes of the executive who's trying to gain that additional power. And so the rhetoric that's come out as a result of these decisions that haven't gone the executive's way have just been obviously hurtful. But you know, it was time for us to respond. Time for everyone to respond. Time for retired judges who have the ability to respond.
Judge Ungaro, pick up on that, because you all have spent your careers on the bench being very careful not to speak out. Now you're being asked to speak out, and you're here because you want to be here. What should be said at this moment about what's going on?
Well, I think we need to recognize what's. You're on. Okay.
Yeah. Hold it up right to your mouth.
I think we need to recognize what the potential here is. Why is the executive pursuing such an aggressive strategy to undermine actually all the institutions other than the executive branch, right? The executive right now, our very aggressive executive, is pushing back against Congress as well as the courts. There's just a tremendous push to garner as much power as possible and to undermine the legitimacy of all of the other institutions. Why? Right? That's the great question. It could be just politics, right? Us versus them is good politics. It could be to intimidate judges, for instance, to rule in favor of administration policies. But it could also be to undermine the institutions so that in the elections that are coming up, there is a lack of confidence in the outcomes.
And there's a lot of speculation about that, and I'd like to touch on that. Judge Duncan, I do want to come to you though on this question about why we're having this discussion right now. And I want to raise what happened. The Department of Justice under this administration, we know because it's been reported widely, it's been reported accurately. They've ignored or violated a number of court orders, judges' orders, especially around immigration. When I guess the most publicized early on was the man from El Salvador, Kilmar Obrega Garcia. There was one news report last year that concluded the administration had not complied with more than 1/3 of the rulings that went against the president's actions. What options does the judiciary have in that situation?
They are limited, and I believe that it diminishes both branches to reach that point. A colleague of mine on the Fourth Circuit wrote an exceptional opinion, Obrega Garcia, about precisely that. The administration may be able to tarnish the judiciary for a time, but at the end of the day, who profits from that? And his point is excellent. It does not serve it serves no purpose to have a weakened executive which cannot enforce the rights of minorities. And I know what that feels like. I grew up in pre-Brown versus the Board of Education South. The schools were desegregated because of the courage of federal judges who stood up and followed the law. So you do run a risk. You asked about the risk. The risk is that if judges are compelled into a compliant or fearful mode, then the rights of those minority individuals, the non-majority, and the judiciary is contra-majoritarian, are going to suffer in the long run. And as a result, the whole will suffer.
Judge Wood, what options do judges have in situations like this one, like these?
Well, the classic option is to hold the person who is not obeying the order in contempt of court. And you can do that in a couple of ways. You can actually literally put them in jail. You can fine them. You can make a fine run every day until the compliance comes forward. So the fine gets bigger and bigger. Judges have been reluctant to I'll call that the nuclear option. And they've been reluctant to go that far.
Why?
To hold, the entire Department of Justice in contempt of court, or to hold the Attorney General, maybe just as the representative of the department, is very strong medicine. Now, the only other time I can think of in my experience that we've seen this is when you look at the period to which Judge Duncan was just referring. You look at the post-Brown versus Board of Education period, and the Supreme Court wrote opinions then in which they said, you may be as convinced as any human being could be that a judicial order is wrong, but the solution is not to disobey that order. The solution is to take an appeal. And if people would do that, and the Chief Justice himself has strongly recommended that, he said, you don't impeach people because you don't agree with them. You also don't just ignore them. You follow the law. I think there is a concern about a whole bunch of side proceedings in contempt that would be even more distracting than these failures to comply. The failures to comply are very unsubtle. I think they're very clear. And I'm a little bit surprised that we haven't reached the contempt stage more often than we have. But I think the judges are reserving it.
Is contempt the only option, or what other options are there?
Well, you can tell the Marshal Service to go issue an order and serve it and see what happens there. You can, it really is the judges don't have a lot of power to enforce their orders. They've got the Marshal Service if they need it. They certainly have public.
Reminds us of President Andrew Jackson, and
Right. Yeah.
Chief Justice Marshall.
Yeah.
He didn't like the outcome.
Yeah.
That's right.
Yeah.
There is also, if the bar would respond, another alternative is judges can make bar complaints. Judges can refer lawyers to the bar for discipline. Judges can refer lawyers to peer committees for discipline. In many instances, unfortunately, the state bar associations are not stepping up to the plate. They're not responding.
Why not?
To those complaints.
Why aren't they?
Well, I think we know from the lawsuits against the
Law firms.
or the law firm lawsuits that there is an effort to intimidate the lawyers.
And the administration's doubled down on that just
Right.
recently.
Oh,
That's
yeah.
right.
Yeah, absolutely.
Or as
There's-
Earl Howell pointed out, kill all the lawyers that we don't like.
Right. Yeah. Judge Boasberg in the District of Columbia is a terrific judge. And he was chief judge of the FISA court when I was a member of that court. A very careful person, very well reasoned. If you look at what he has done in the case that he has, the immigration case, where it started out with, hey, don't send those people out of the country until we have a hearing. I want to make sure their due process rights were observed. And then the planes leave. You have a Department of Justice lawyer who comes before the court and says, I'm not sure why we did that. It was a mistake. And that was the last statement he made on behalf of the Department of Justice, although he's filed a complaint for whistleblower violation. But Judge Boasberg, as Judge Wood has just said, you have to be so careful in the contempt proceedings to identify specifically who is responsible, and then limit the conduct that is contemptible as narrowly as possible, or it won't be successful. And he has very meticulously tried to do that over the last year now. And the interference has been just it's like a hurricane in your chambers. He's got senators trying to impeach him.
Mm-hmm.
He's got they've asked the Court of Appeals chief judge in D.C. to prevent him from making any more rulings. Extraordinary attempts to silence him. So it's a really difficult path, as Judge Wood suggested.
There is one more thing that we did at one point in the Seventh Circuit. It was before the current round of immigration things. It was an extradition from Chicago to one of the Northern European countries. And the person responsible for this at the Department of Justice lied to the court about where this individual was. And
Is this in this current administration?
No, this was
in a previous.
in a previous administration. This department, I'm just saying it in terms of what kind of remedy there could be. So this lawyer for the Justice Department lied. They put the guy in the plane and off he went to the country of extradition, by which time he was outside the jurisdiction of the United States. The ability of the court to do anything was completely thwarted. But what we did do is we called the lawyer on the carpet, as Judge Ungaro was saying, and we formally reprimanded the lawyer. It was a very serious blot on that lawyer's record at the Department of Justice.
This is someone who works for the Federal Department of Justice.
Yes.
This is a Department of Justice that would have cared at that point in time.
I think so.
And Judge Duncan, what else would you add about options that judges have or don't have?
I was just going to point out, in addition to what Judge O'Grady said, Judge Boasberg has been the subject of administrative proceedings against him for expressing his views or his purported views in private. And so the hearing had to be held in a circuit next door to Judge Wood's circuit to consider a charge against the sitting judge.
Hold your microphone. We can't hear you.
Charge against a sitting judge, Judge Boasberg, for something he did. It wasn't even clear that he said what was attributed to him.
And as we said, impeachment. I do want to get to on what judges' options are. I just want to, how effective are strongly worded opinions? And I want to cite what one U.S. district judge, and he's in San Antonio, and I don't think I'm pronouncing his name correctly. Fred, is it Beery or Byrie? He's a district judge. He wrote this year, this was in ordering, you all read about this case, that it was illegal for the administration to arrest an immigrant and his 5-year-old son. In the opinion, which was aimed at the administration, he wrote in part, quote, "For some among us, the perfidious lust for unbridled power and the imposition of cruelty in its quest know no bounds and are bereft of human decency, and the rule of law be damned." And at the end of his 2-page opinion, he included a photograph of this 5-year-old wearing a bunny hat and a Spider-Man backpack. So my question is, strongly worded opinions, can they have an effect or not? He was also criticized for doing this.
I worry that when we respond in that tone, that we run the risk of negatively affecting our own credibility. And that's one of the things I'm just extraordinarily careful about when I talk about almost any of the issues affecting judges now. I do not refer to the occupant of the White House. I talk about structure, the things that concern me about what is happening to our constitutional structure and why we should be concerned about it. I cannot fault. I understand I read that opinion too. I understand the level of his vehemence. I do not know in the long run what it will accomplish.
I look at the polling on concerning the approval of the rule of law and in following judges' orders. It's still at about 81%. The public believes that when a judge issues an order, it should be followed. I wish it was higher. Frankly, 81% in today's environment is pretty good.
Huge.
But that's in large part why we're here, is to spread the word to the public that you can't compromise the rule of law, and that there's a procedure for not agreeing with what a judge does. And as you appeal his ruling, and you'll get at least a 3-judge panel at the Court of Appeals. You may get the entire Court of Appeals to look at the issue. And if you don't like that decision, then you get the Supreme Court, where you've got 9 justices who look at it. That's how our founders built our system. It's a wonderful system. We just have to make sure that people understand they need to have faith in it, or we lose our republic.
But here's what worries me when we think of polls, and that is that the general opinion of the judiciary has been going down. It's at an all-time low. And I think there's blame to be spread, but one of the things that I think has contributed to that has been the tone of many opinions at the Supreme Court level. There was one justice who's not in the court anymore, who would write these wildly worded criticisms of his colleagues on the court, sometimes a particular colleague, sometimes, with the dissenters, And when the public picks that up and reads it, it looks like a bar fight. And it doesn't make them think that these are 9 wise people doing their best to answer extremely difficult questions. The other thing I'll say about the Supreme Court, and this may be a structural problem that we have to revisit. Yes, after the Court of Appeals has ruled, you can try to get the Supreme Court to take your case. But in terms of fully taking the case, remember they take less than 1% of the requests that are given to them. There might be 7,000, the numbers bounce around, but maybe 6,000 of these requests called petitions for writ of certiorari, and the court might take 65. Well, people aren't being heard. They're not getting that final resolution. They're left with just this little order that says cert denied, and they're not sure. Now, there is the emergency docket, which is a whole different set of problems, but you aren't getting measured things from the Supreme Court the way you should, and you're not getting, in some ways, enough Supreme Court attention to let them fulfill the role of judicial review, another thing not mentioned in the Constitution, that they have traditionally had.
And I was going to ask you about the Supreme Court, or a question related to this in a few minutes, but I'll go ahead and bring it up. Now, this administration is turning to the Supreme Court to appeal decisions it doesn't like in the lower courts. Are they being heard more frequently because they're the administration? What does that look like? And is that, what do we make of that? Is that just the way it's going to be from now on? I mean, what do you see?
I read a statistic recently, and I'm not sure, perhaps you sent it, Judge Ungaro, about you're talking about, I assume you're talking about the so-called shadow docket, which is the Supreme Court's response to emergency requests for orders They're not extensively briefed or orally argued. They tend to be ad hoc responses to a specific situation. The problem, and the statistic that I read that I found quite remarkable is that, and correct me if I'm wrong here, that there have been 90% more such petitions within the past year than there have been.
Filed by the administration?
Yes.
Yeah.
It's usually maybe 25, 30%.
That's right. It's a much higher number at this point. And it's always been the case that the Solicitor General has been, they sometimes call the Solicitor General the 10th Justice. The justices have traditionally maybe put a thumb in the scale. If the Solicitor General said, this is the public policy of the United States, we really need an answer from you, please take this case, they've done it. But they're going to that well all the time. And they're doing it in circumstances where you have to ask, would it really harm the process to wait another 6 months to let this come up in the ordinary course where it's been thought about carefully by the lower court, different views have been aired, maybe different circuits have said different things. You just get a much fuller look at the picture if you follow the usual procedures, which they are not.
But is it harming the system? Is it harming the judiciary that they're choosing to do this? I mean, as you said, Judge Duncan, what the result has been, and I want you to weigh in too, Judge Ungaro, the result is these very narrow emergency or expedited opinions.
There's a lack of clarity. Oh, I'm sorry.
No, well, they haven't all been so narrow. One of the things that happened is that the shadow docket undermined nationwide injunctions, which was something that many administrations had pursued. It was just an unusual forum in order to do.
You're right.
In order for them to do that.
And remind everybody what that meant. That meant, well, when you
Right, unfortunately,
when you
that's
limit
part of our
nationwide
job, is to
injunctions.
explain things, right? So oftentimes, not oftentimes, but occasionally, district courts would be presented with constitutional issues that merited injunctive relief, meaning a stay, meaning you can't do it. If it involved a constitutional principle, district judges at times imposed the stay, the ability to continue to conduct themselves the way they were nationally. And there was a lot of controversy about nationwide injunctions and whether judges ought to be exercising their jurisdiction in that fashion. So as a result of one of the cases that made it to the shadow docket, basically nationwide injunctions have been abolished. So you can have a situation where in Florida, a judge could find that a government agency was acting illegally and could enjoin it. And in California, a judge could find the opposite and the opposite result would obtain.
And the Supreme Court basically said what?
That's okay.
It's okay.
Yes.
This contradiction.
Right.
They did leave a crack open in the Trump against CASA case, though, because what they said is if you properly certify a class action, then
Right.
you've structured the case as a nationwide case. The other thing they didn't take into account is, I'll give you two examples. One is what happened to the various sanctuary city ordinances. And they tended to be enjoined at the local level because every city had their own exceptions. Every city had their own rules for this. The other example would be, should the FDA withdraw its acceptance of drug X? And it's very hard to make that, as Judge Ungaro was saying. It's very hard to even talk about that in anything but just a nationwide way. The FDA's either withdrawn it or it hasn't.
One of the other things that we've seen is we've heard the president, members of his administration, frequently attack the legitimacy of judges and the courts. He has called judges, and Judge Duncan, this came up in your conversation with Senator Tillis. He's called judges who rule against him, quote, radical left lunatics, quote, unpatriotic. After the Supreme Court ruled against him on the tariff case, the president stated that the 3 Republican appointed justices who voted with the majority, including the Chief Justice, are, quote, fools, quote, lapdogs for the rhinos, and, quote, disloyal to our Constitution. And as you pointed out, he also said or claimed that they were swayed by foreign interests. What does, we heard what Senator Tillis thinks about all this. What does all this mean? What are the consequences for the federal judiciary when we have this kind of public denunciation
For
of the
one
court?
thing, it empowers the people who are on social media to take it from there and become even more aggressive in their attacks on judges. And that is a big problem. When I talk to my former colleagues, their concern for their safety largely comes from what's going on social media.
I mean, what does it mean when this happens?
Well, it doesn't change what a judge does. There isn't anybody who has changed that I know of, and any of us know of, that changes what they're going to do in a specific case. They're going to do what they have to do as judges. They took an oath. They follow the rule of law. They resolve questions that are put before them. They ignore the interference. But should it be necessary that not only that you're threatened or you're doxxed or you have AI videos made of you that are put up on YouTube, or that your kids are threatened, or other actions against family members that as you saw the statistics, 500. There's only 600 or 700 federal judges, Article III judges in the country, and you have 500 of them at least who have been threatened over the last couple of years. That's appalling. So you have, but what happens is the erosion of the faith of the public in the decision that the judge is making. Doesn't change the judge's decision. The perception is what's changing. And that, again, as I repeat myself, that's why we have to get out in the bar associations and in the public and in the high schools and then and remind people why our judiciary is there and what their role is. It's not to be politicians. It's to rule on issues that are brought before them. In Virginia, where I'm from, civics is not even taught in high school. I'm not sure about North Carolina, but the amount of information that is taught in high school to kids is almost nil. They don't understand it. So they're, it's far more subject to being influenced by social media.
About a week ago, 60 Minutes did a feature on judicial threats to judges, and one of the members of our coalition spoke, and it has to, I would imagine, have an effect on who wants to take on that role. First, the higher the level of court, the more challenging confirmation becomes more of a challenge as the process becomes more politicized. But once you're appointed, there are significant limits. You can't teach, you can't earn certain outside income. But I don't think any of us appreciated the extent to which we might be putting our families at risk. And you're all aware of the situation involving Esther Salas in New Jersey, whose son was murdered by a disgruntled litigant, and some of the doxing that has been occurring has involved sending pizzas to the children of sitting judges in the name of the murdered boy, which is, in my opinion, unconscionable. That simply cannot be.
I mean, just to pick up on what Judge O'Grady said, the the statistics I've seen, the U.S. Marshal Service reported there were well over 500 threats to federal judges last year. They're well over, by now, over 200 so far this year. We're only in early March. I mean, I'm just trying to wrap my head around the fact that members of Congress have been facing threats in recent years with the rise of social media. But I mean, as we think about what can the judiciary do, if anything, about this? I mean, the Marshal Service is there to protect you, but your families are involved. I think the public doesn't recognize the extent to which this is deteriorated.
I might say that in Illinois, we had a similar tragedy back in 2005 when Joan Lefkoe's mother and husband were murdered by a disgruntled litigant in the basement of her house. One of her daughters happened to come home while the guy was still in the building and luckily left before he realized that she was there. And so legislation has been passed that entitled judges to take steps to erase themselves from the internet. You don't have to put your home address on your driver's license. You can put the court address. All of these are incremental measures. All of them can be defeated, I'm sure, by somebody with enough determination. But on the other hand, maybe you just have to do what you can do. You start with measures to allow judges to be a little more invisible. This terrible rhetoric, it fans the flames of this small number of people who would do such things.
What would you want to add anything to this, Judge O'Grady?
Can I, only a slight detour. I was looking at, being called all the ugly names from the administration. I was reading some statistics that there were 204 cases where district courts during 2025 where they'd ruled against the Trump administration, and 154 of them, those 154 rulings came from 121 different district judges appointed by 7 different presidents, including President Trump, in 29 different district courts across 10 circuits. 41 were presided over by Republican-appointed judges, half of whom were appointed by President Trump. So statistically, it's dishonest to make these claims that we're talking about a liberal group of select judges in this country who are obstructing the administration's agenda. It's just not true. And we have to get that message out as well.
I'll let that sit. That's a remarkable statement. And meanwhile, we have Senator Ted Cruz and other members of Congress calling for the impeachment of judges, Judge Boasberg and other judges over what they claim is an overreach of judicial authority and so on. I think we heard, Judge Duncan, you asked Senator Tillis about that. Why does it matter that this is happening right now?
It exacerbates an already dangerous situation and contributes to the misinformation that the public is confronted with. That all we have to do to get rid of a judge whose opinions are contrary to our point of view is to have a person in Congress introduce a resolution calling for their impeachment. I don't think anyone who opines that should happen even understands how the impeachment process works. It doesn't start in the Senate. I don't think people understand what it looks like. It just sounds good, or it sounds draconian.
Can I add that I think there's a real role for public education here, because number one, it's fine to criticize a judge's opinion. You can write an op-ed, or you can, write a book if you want to, talking about how ill-considered some judge's decision was. Judges get that, that's part of the job. But there are mechanisms where a judge who is personally misbehaving, not just getting the law wrong, but, taking bribes or falling asleep on the bench or, going crazy or whatever it is, there's a whole statutory system under the Judicial Conduct and Disability law that allows the chief judge of the circuit, which I was for 7 years, to review the complaint. If you think there's any kind of dispute of fact, you appoint a committee. The committee has subpoena power. They look into what's happening. And you usually actually can resolve it with the judge because it covers both misconduct, the person who stuffs, lots of $20 bills in his freezer, as well as disability. And I had a couple of judges over the years I was chief judge who, judges are human, right? And these were older people and they began to suffer from dementia. That happens to some people, and it's very sad when it happens, but people don't tend to recognize it. So you need some way of getting it off. But we've got actually pretty decent tools for dealing with a judge who at a personal level needs some intervention for some reason. If it's a legal error, take an appeal. It's that simple, but we are not left without tools for judges who need something else.
So another tool is recusal, right? You can file a motion to the chief judge and ask that a judge be recused from a case because of bias or prejudice. But I think it's important to recognize that these impeachment, some, not all, some of them are just silly, like the articles of impeachment against Judge Boardman for the sentence she imposed on the defendant in the who was accused of trying to kill Justice Kavanaugh. That's just silly, right? That's obviously an appeal. But some of the other articles of impeachment are consistent with this push for more and more executive power. They're not just saying, oh, the judge made a mistake. What they're saying is the judge knowingly overstepped into Article 2 power. And so that's kind of a qualitative difference.
And I'm looking at the clock and I do want to leave time here for any questions from you in the audience. And before I do that though, I want you all to weigh in on something that Judge Ungaro raised at the outset, at the early part of our conversation, and that is what is going on. There's been a lot written about this, and if to the extent it has the effect of undermining the public's trust in the judiciary period, the federal judiciary and the judiciary period, it may have something to do with a coming election. I mean, what if there are moves by the administration, or you could say any administration, but let's talk about this one, to step in, to take extrajudicial measures, to, among other things, seize ballots. We've seen that happen in Georgia and Fulton County, and whatever other options are available. What can judges do? Do you wait you have to wait, obviously, for the case to come to you, but what should we as citizens be thinking about at this point in that regard? I want to come back to you, Judge Ungaro, because you're the one who raised it.
Well, I think as citizens, hopefully educated, sensitive, rational people, we would recognize an attempt to use the judicial system in order to achieve a particular outcome in an election as something grossly wrong and completely undermining of the republic that Judge Duncan spoke about earlier. What can judges do? The only thing judges can do is to be the principled decision makers that they've always tried to be, to write with clarity, to not lose their cool, to have humility, and to do their best they can within the constraints they have to get their point across. That's about all they can do. We're the weakest branch.
Well, from a mechanism standpoint, the U.S. Attorney's Office and a district judge from the Eastern District of Virginia, are always on duty to try and handle emergency matters. As you are well aware, and we're all well aware, the states control elections, and they have their own state rules. There's clear constitutional law that says that you can't have law enforcement within a certain area within the voting booths, or any attempt to influence who votes or whether they vote. The reality is it's hard to get that out to the public. I was on behalf of Keep Our Republic out in California recently, and the Latino community was asking that same question. What do we do? Do we vote? Who's going to be watching if we do vote? And they're scared to death to go to the polls. And the only way to deal with that, I think, is in the community. It's got to be within the community to get to give assurances that people can safely vote. If something happens like it happened in Georgia, which fortunately was long after the election, and the votes had been counted, then the courts can get involved. But it's up to the community and community activists, I think, to get the vote out to begin the process.
And there definitely are lawyers who are preparing as we speak for that kind of scenario. And I'll just add a couple of things. One is that going all the way back to 250 years ago, the people who structured, actually not 250, I'll say 1787, the Constitution structured us as a two-tiered kind of government. We have the states and we have the federal government. Now, if you're from a place like Chicago, which I'm from, where the old adage, vote early, vote often, was for a long time not just imaginary, the U.S. Attorney's Office would impound the ballots, but the state enforcement officials have their own role in this, and they are a place that one can go. They're a place to which one can complain. And I think we should not underestimate the role of the states in today's world. It's a more immediate little d democratic line to the people who are governing you. And the only other thing I'll say, this is a commercial, but the American Law Institute, of which I'm the director, has two things which are of some potential help. One is a set of principles that would govern litigation after an election. What kind of timetable should be followed? What sort of issues might come up? And they also have a code of conduct for election officials, totally voluntary, but ideas of what we might expect after we saw the treatment of some of the officials from Fulton County, which was so unfortunate. So there are different points of pressure, and we shouldn't just think myopically that it's either the U.S. attorney or nobody, because that's not so.
It's important. Anyone else that you want to comment here and now? What's our mechanism for hearing from all of you? Okay.
Yes. Okay, here it is. So if you have any questions, and then if you've passed your card down to the end of the row, please do so now. We just have time for maybe a few, and I do already have some that have already been collected. But to begin, I would actually ask this gentleman, he wanted directly.
Sure. We'd love to hear it.
If you don't mind, share your name and where you're from.
My name is James Williams. I'm a resident of Carborough, and I am an attorney and a co-founder and board member of North Carolina Lawyers for the Rule of Law. And my question is related to what role do you see lawyers playing in addressing this crisis that is confronting us? I think the response up to this point has been too muted and too timid. And I think about how lawyers in, I believe, Pakistan and Poland responded to a similar crisis, and whether or not we're at a moment where we need this robust response in this country.
What do you mean by, can you define the crisis you're referring to?
The crisis I'm talking about is the attack, not just on judges, which is certainly crucial and critical, on the rule of law, I would say, on the concept of democracy itself, on attorneys and their ability to represent their clients and choose their clients. So I think this experiment we call democracy is under attack by this administration, and how we respond will answer the question of whether we keep our republic.
Who wants to tackle?
Well, I just want to, I would like to just say thank you for your question, because I think it is very important. We talk a lot about the independence of the judiciary and the rule of law and the role of judges, but the judges are nowhere without the lawyers. The lawyers need to speak out. They need to be willing to take unpopular causes. They need to be willing to take on the administration and this grab for executive power. Unfortunately, as we know, a lot of the big law firms caved.
Not all.
But not all. Right. And some of them were courageous, and it looks like they probably were, at least they've prevailed so far. We'll see what the Supreme Court does.
Anybody else on what lawyers should be doing?
There are also organizations that look at the rights of law firms, and it's easy. I guess I understand that no one wants to put themselves at risk. I understand that, but if we aren't heard, then the results are just, as you suggest, too dire to contemplate. And the more people we can bring under the tent of speaking out and trying to protect our interests and our security, the better.
Thank you.
Thank you.
Such an important question. Another question.
Yes, next question right here, sir. You'll stand up and introduce.
Hey, my name is Beck Whitehead. I'm a junior at NC State. Hi, Professor Lane.
I'm sorry, you're a junior where?
At NC State
At
here.
NC State?
And I do kind of political and civic engagement work on campus. And my question is, as a college student, I worry about kind of wealth and power control and politics, especially the modern day. And I was hoping if any of you guys would be willing to talk about the role of the Citizens United case and how that kind of works in terms of super PACs and kind of wealth and media control.
So this is to a subject that the judges have to rule on sometime. This is Citizens United. Does anybody want to, who wants to tackle?
I wrote a brief article about that in a book that was published recently. It's a constitutionally based decision. So it's with us until the Supreme Court changes its mind about the scope of the First Amendment. And so then the question is, how do you work under it? Because what it sort of says is corporations are just groups, just like unions are groups and other things are groups. And it's made campaign finance reform very difficult, I'll just say. And so the way people are attacking it at this point is kind of to fight fire with fire. You've seen the incredible increase in the price tag that goes along with elections. The Wisconsin Supreme Court election, it was just off the charts. And frankly, that's what I think is going to happen. There are some little cracks in the facade. Disclosure of who's giving the money is one thing that the court said was still possible, actually over the dissent of one of the justices. But I think we should push on that. If we seriously are concerned about foreign interference in our elections, which is a topic that I think should be taken seriously, that to me suggests even more strongly that there should be disclosure, because, you know, if you have 2 or 3 layers of corporations, who knows at the top of the line. So there are a few things that can be done that I think would be helpful, but not too many given the constitutional basis.
Does any of you think there's a prospect in the near term for overturning? No. All heads shaking. No. The next question.
Sure. This will be our final question, unfortunately, just due to a short time. And this was a question submitted from one of the audience members. In a culture so relentlessly driven by media and extreme statements, how can we protect the judiciary without strong statements?
How can we protect the judiciary
Without strong statements? Like, how do we do that?
being made by the judges themselves? Is that the question, the presumption?
Whomever.
Whoever crafted the question. How can we protect the judiciary unless the judges speak up is, I think, what
Yes.
the question is.
Well, and maybe it's I think that that you can't go to the level of name calling because then you're not really even having a discussion. And it's hard, but the judiciary has to maintain its integrity as an institution. And I think that limits what they can say.
It's got to come from outside of the judiciary. The judicial council just modified its rules, and now sitting judges can now talk about the rule of law and the importance of an independent judiciary for the first time. But they can't talk about their cases. They can't talk about criticisms. It was a little bit of a gift, but not much. And so it's town halls, it's bar associations. It's got to come from groups like you all who come out. Mm-hmm. And when you leave here and you say, let's talk about the foundation of our republic and how important it is. And if you want an autocracy, we can go look at some of the Eastern European countries and see how that's worked out. But if you want an independent judiciary, which is a co-equal branch, then we've got to fight for it. This is a great stress test we're under right now, and we're going to pass it. But everybody has got to contribute to make that happen.
Well, I don't think that continuing the escalation is going to solve the problem. Like I said before, I think that, and like Judge Wood just said, it's the role of the judges to have humility and maintain their dignity and to express themselves clearly. And the problem of social media is really a structural social problem that's beyond their control. It's a much bigger problem than just judges. And the real question is, what are we all going to do about the problem of a vicious social media that just feeds on itself?
And the people driving that.
If I may, I agree with everything that my colleagues have said. I shared Judge O'Grady's sense that was a nice little move
Microphone.
on the part of the judicial conference to allow sitting judges to speak out on rule of law issues. Think about it. Before that, we're not supposed to even talk about such issues as judicial independence. So that's a micro step in the right direction. I also think that the Chief Justice deserves credit for speaking out about the process, about if you object, if you disagree with an opinion, appeal it. I think that the pressure on the Supreme Court is unfortunate. I think it's part of what's driving the push behind the shadow docket, and it's led to the numbers of cases that have been decided summarily. But everyone will have a role and be able to speak to it and has to use that role and that platform as best they can to speak out.
Okay, we're gonna end, but I want to end with asking each one of you in brief, why does it matter that we continue to have a strong judiciary and that the public respects the judiciary? Why does it matter in this country?
There is I'm old. Has anybody ever seen the movie A Man for All Seasons? There's this tale about the
Microphone.
protagonist's irritating son-in-law who said that he would break. Hank, are you nodding your head? He said, "Would you break the law to catch the devil?" And the ardent young son-in-law said, "Yes." And the Man for All Seasons said, "And what happens when you have gone from one end of England to the other and laid waste to every law in the land? What protects you when the devil turns around?" And that's what that's what I live with. What does a minority, what do I or someone else, and I do believe that democracies are judged on how they treat the vulnerable. It's not coincidental that the people who are significantly under threat at the moment are illegal immigrants. What happens when what's left to protect if we don't uphold the law when it's not convenient?
Judge Ungaro.
I don't know that I can best that, but certainly our economic system and our system of social justice needs a system of laws that is fair, predictable, and reliable. It's a foundational principle of our Constitution that we have a rule of law of that character. And if we don't have it, we don't have our republic.
Well, I agree with what my colleagues have said, and you know, what happens when they come after you that Judge Duncan just talked about is just fascinating. For some of the people I've talked to and lawyers representing big corporations, I've said, what happens when they no longer want you to litigate a case in courtroom, that they think they've got a better chance of going to a lobbyist, getting a statute changed, or paying off somebody because the system doesn't work anymore? If for no other reason than that, you ought to be screaming to the heavens about how important the rule of law is, because the alternative is a disaster.
Well, what I think of in response to that question is the starting point that, if you will, as modified by modern times, the words in the Declaration of Independence, it says, all men are created equal. Let's just assume that means all of us, all humans are equal. We have equal rights, equal dignity. And the way that's achieved in our country is through this idea that we have a representative body that we call the Congress that passes the laws. They debate them, they think about them, as Justice Gorsuch said in his opinion in the tariff case. It's a good thing, it's not a bad thing. We have the executive who makes sure those laws are being enforced. And when it's unclear, we have the courts to resolve things. We have the courts to make sure that this isn't just writing on a piece of paper, that there are consequences to violating civil rights laws, there are consequences to violating criminal laws, there are consequences to violating environmental laws, or whatever kind of law you want to put in there. They are the laws that our democratically elected representatives, when the system is working the way it should, have decided to create for us. And you need the judiciary in that final backstop position, because otherwise, as we've seen, things can go off the rails. And so I think having a robust judiciary that's able independently to call it as they see it and make sure the Constitution and the statutes are enforced is essential.
Judge Diane Wood, Judge Liam O'Grady, Judge Ursula Ungaro, Judge Allyson Duncan, thank you all very much. What a wonderful conversation.
Thank you.
Thank you very much. On behalf of Keep Our Republic, sincerely, with utmost sincerity of heart, just appreciate your time and your presence with us here in North Carolina. So ladies and gentlemen, keep an eye on Keep Our Republic. As Judge O'Grady said, communities are what's the heart of the work, and how to educate, whether it's from elections to the courts. So I hope you'll continue to partner with us in this work as we get started here in North Carolina in the year ahead. Again, thank you to the A.J. Fletcher Foundation for their support tonight, and I hope you guys have a great evening. Thank you.